We know Bryan Kohberger, who is set to go to trial in August of 2025, studied criminology under Dr. Catherine Ramsland, and thus is likely well-versed in Ted Bundy, his crimes, and his ultimate punishment in a special chair, if you know what I mean. Flip the switch and razzle-dazzle. One of Bundy's former defense attorneys recently described a fascinating parallel between Bundy's last crimes and the charges against Kohberger. Attorney John Henry Brown spoke to Fox News and pointed out that Bundy escaped from jail in Colorado, where the blank penalty, I'm going to call it the DP, would soon be found unconstitutional, only to drive to Florida, commit red rums, and end up on death row. Bundy then messed up his plea deal, which would have prevented him from being unalived in that chair. Brown noted that Kohberger is accused of driving from Washington State to Idaho to commit a quadruple red rum. So essentially, Kohberger allegedly drove 10 miles from a state, Washington, that doesn't have the DP and where there is an active mental health defense, i.e. insanity defense, to a state, Idaho, where there is no insanity defense and where the PD is alive and well. And in fact, they will even use sharpshooters if necessary to get the job done. If Kohberger is the perpetrator, then he's not as criminally savvy as he may have thought, or getting caught wasn't part of his plan, or he simply couldn't control his impulses. Kohberger, like Bundy, is accused of 1. Unaliving 4 college students, 2. Doing it before dawn, 3. Entering through a back door, and 4. Doing this while some of the students were sleeping. Brown believes that Idaho prosecutors should share their theory about a potential motive because it would be of interest to the jurors. They're not required to come up with a motive, but we know that jurors tend to want one. Brown said that in Bundy's case, as his victims stacked up, it became very clear that his motive was more about a power struggle than sex. Brown pointed out that not all of Bundy's victims were SA'd. Brown went on to say that if he were one of Kohberger's lawyers, he would start playing offense a lot, because you're not going to get anywhere in a case like this playing nice. Brown recommends that Kohberger's team continues to make life for the prosecution as difficult as possible in order to aggressively attack the case. And Kohberger's team has been doing this, but Brown also worries that the defense's attack may have turned Judge Hippler off. Kohberger's team filed a motion for a Franks hearing, which is their attempt to throw out some of the search warrants in the case. But Judge Hippler slapped their hands and told them to refile it with specific citations and references because they apparently did not do this. And Hippler said it's not his job to sift through 2,000 pages of exhibits to figure out what the defense is talking about. Here is what Judge Hippler said, quote, "By way of example, defendant cites generally to Exhibit D9 for the proposition that law enforcement's vehicle expert felt more comfortable setting the date range of 2011 to 2013 for the Elantra. That exhibit is over 100 pages of duplicative emails. Defendant does not identify which email supports his proposition. The court will not do counsel's job and scour the exhibit to decide what portions defendant must be suggesting supports his assertion. My bad. Brown also suggested that the defense may want to consider whether to waive Kohberger's right to be tried before a jury and to instead maybe leave his fate in the hands of the judge. Brown believes a lot of jurors, or potential jurors, may have already made their minds up because the case is so high profile. Mathematically, Brown believes it's better that Kohberger does go to trial and does have a jury.